The ACC files a motion to dismiss or stay in the state of Florida.
The ACC and FSU lawsuits are always in the news, so we're back on the big mountain to keep you updated.
Hey, it's great to have you here on the mountain. I am JY, and this is my good friend Steve. And Steve, we're going to do an episode on the ACC's motion to dismiss or stay that they filed in Florida on Friday, February 16th. This was a 44-page document. If you include all the exhibits, it was 141 documents. It was a real pleasure to get through all of this sucker, but filed in Leon County here. And this episode is to go over it on somewhat high level. We're going to get a little deep on some of this stuff, but if I went deep on everything, we'd be here for 2 hours. So I'm going to stay high level on some of this. We will get down into some more detail on some of these items, and we may do some deeper dives on these episodes or on these topics in a future episode. So the first thing I want to talk about here is what the ACC is talking about here in their motion. So the first item that the ACC moves to dismiss is because Florida courts lack of venue or personal jurisdiction. They then argue that North Carolina has priority over this action, and as such, Florida law requires a stay pending the North Carolina case. And third, after agreeing with a stay action, any items that would come out of the North Carolina courts would only move, or anything that came out that wasn't ruled in North Carolina would go to Florida. So if it's ruled on in North Carolina, it's done. Florida only gets whatever's left over, according to the ACC. Their motions to dismiss the ACC amended complaint are fourfold. Number one, FSU has not pleaded a legally cognizable theory for establishing the Florida court has personal jurisdiction over the ACC. Number two, the venue is not proper in a Florida court. Number three, FSU's penalty claim is not ripe because FSU does not allege they have withdrawn from the conference or they even intend to withdraw from the conference. And number four, not one of FSU's 7 counts state a cause of action. Before we go into this any further, I do want to point out just some three big items that, quite frankly, as we get into the claims, it may not even matter because these are going to happen so early on that you may not even hear the details of the claims. And they are the venue, that's going to be huge. Jurisdiction is going to be huge. And we're going to get into something later on, the statute of limitations specific to North Carolina law and where this may actually end up. But let's talk about in a little more detail this personal jurisdiction. To put it bluntly, the ACC claims that FSU has not even attempted to plead jurisdiction over the ACC as required by Florida law. They stake their allegations solely on the federal diversity jurisdiction law. This, they say, is irrelevant to personal jurisdiction. Number two, the venue is not proper. The ACC claims that by FSU using 47.011 of the Florida statutes, this isn't proper because this expressly states that this shall not apply to actions against non-residents. Jurisdiction, they remind, is not the same as venue, and they cannot be confounded. The penalty claim is not ripe. FSU has not alleged that it intends to withdraw, and there's no allegation of a withdrawal. Florida law requires that before a claim for declaratory relief can proceed, there needs to be an actual and present need for declaration, and that declaration should deal in the present state of facts. Let's get into the 7 complaints that FSU filed here. They talk about all 7 of them. I'm going to be pretty high level on a few. I'm going to dig a little deeper into a few. The first one is the restraint of trade. These are to protect individual consumers, not the market. Antitrust laws are all about the citizens not being harmed, in the ACC's point of view. Number 2, unenforceable penalties. Liquidated damages versus alternative performance. This is a big one. I'm probably going to bring this up again in a little bit later on in the episode. But the ACC states that the ACC Constitution and North Carolina law does not treat withdrawal payments as liquidated damages. They state that a member does not have to complete the contract. they can actually agree to alternative performance. So what are the two forms of performance? According to the ACC, number one, they can receive the tens of millions of dollars that is in the grant of rights and be a member of the ACC. Or number two, they can choose to leave and they can make the withdrawal payment. Remember, we've been talking about this whole liquidated damages issue for quite some time. We did breakout episodes on this. We had lawyers that have brought this up, and this was an issue that a few lawyers said, yeah, there could be some smoke here for the ACC in terms of FSU having a good case. So they're quantifying this as an alternate performance, not as a liquidated damage. Number three, breach of contract. ACC stipulates many reasons that the claims fail, or this claim fails. In summary, the ACC does not have a contractual obligation to FSU to do the things that they are alleging. There is no basis for most of the alleged breaches. Number four, we've talked about this one a lot, Steve, and I'm going to summarize their findings here, or their response here in one sentence. Breach of fiduciary responsibility. The ACC, according to the ACC, there is no fiduciary responsibilities to their individual members. Number five, there has been no frustration of contractual purpose. Again, the ACC claims these are baseless. Number six, some unenforceable for other reasons. Speaking to the validity of the contract, the ACC says that any consideration makes this contract binding. Also, they discuss the contract, and I want to remind viewers that we've had other viewers about the signatures on the grant of rights. I know there's a lot of smoke out there right now that it wasn't signed appropriately, it didn't follow Florida law, things like that. Again, you can get the link above. That was our last episode. But I'm going to dive into this with some opinions of mine here real quick that we didn't talk about because we had a question on the last episode. And just to remind everyone, they probably already know this, especially if you're an FSU fan, but the grant of rights and the amended grant of rights were signed by the university presidents. They were actually signed by two different university presidents because there was about 3 years in between them. As we stated in that video, the reason that there's apparent authority for these presidents, also that there's been performance of these contracts, is huge. I would add to that a third item to say, clearly, the internal ongoings, at least at the high levels of Florida State University, allow a president to sign contracts. Whether that's correct or not under Florida law, that's what FSU is doing. And I'm sure there's a plethora of other contracts that have been signed by Florida State University presidents. So that's JY just opining on that a little bit. We kind of said there's a lot of smoke, probably not a lot of fire there, but we will see. And number 7, the unenforceable penalties. FSU allegations are not procedural or substantive. They lastly go into this whole relief of retroactive withdrawal. So as we talked about, FSU in all 7 of their claims, they put a sentence at the very end of every claim that basically just says, hey, if this claim is found to be accurate and we're ruled to be in favor, then we actually are going to file a motion of withdrawal back a year ago so that we can get out here in 2024. ACC brings this up and they state that all members, FSU and all members, must follow the Constitution for withdrawal, and they have not. FSU has not. They are clear that they have not. No legal basis. There is no legal basis for rewriting the ACC Constitution for withdrawal. So I'm going to stop there, Steve. I want to give it to you for some opinions. Then we're going to get into what they call the defenses that doom several of their claims. So I'll stop there. What are you thinking?
So first of all, the thing that made me, when I first read this, when I've read synopsis, and even when you were reading this, the thing that makes me just laugh out loud, because it is so ridiculous, is for the ACC to claim that they have no fiduciary duty to their members. I cannot see a judge, probably in any state, holding that to be true. I think it's ridiculous just on its face. So that kind of jumped out at me. Now, the other point, we did a whole other episode of this. You talked about it. There's a lot of Florida State fans that are putting all their eggs in this basket of these signatures, that the contracts were not approved by the board. Their board of trustees were instead signed by the president of the university, 2 different presidents, like you mentioned. To me, that one, they're just. I don't put a lot of faith in that argument for a couple of reasons that you mentioned. One is the president. It looks to me like, and I think it's reasonable to conclude that the president were operating with apparent authority. Yeah. They've probably done this other times, like you've mentioned. So, and if they have, that's pretty easy to show. And then also the performance part. They've been performing under this. The president signed it, and they've been happily performing under this contract. They didn't bring this before, so I think the water's already been let out of the tub on that one. So that tub holds no water for me at this point. So I just, for Florida State fans, I know some people pushed back on this on our last episode, but if you're putting all your hopes in that basket, I don't think that's a good one to go for. Now I do want to talk about some other things. First of all, the Constitution of the ACC is a contract. Okay, they can call it whatever we want. We can call it bylaws. We can call it a constitution. We can call it our 12 ACC commandments, whatever we want to do, whatever we want to call it, but it is a contract. And so in Florida State is alleging bad faith, bad acting on the part of the ACC, and they're asking to be basically let out of this contract, because of the bad dealings by the ACC. And so they've written, they've filed suits, now I think in 2 different states, saying that they want to be out of this contract and why. And so to me, for the ACC to cling to that, well, they haven't done what they, what the Constitution says, so they haven't actually asked to be let out. That doesn't hold any water to me, because of the fact that they filed suit. They have in there, they have a date, hey, if any of these conditions are true, we want to be out of it as of last August. So I think that's going to be a hard one for them, because basically if the judge finds that the ACC acted in bad faith in any of these myriad ways, I think that's an out for them for that. Yeah. So moving on, the next part, so I totally understand it. It's very good strategy. We talked about that from the beginning for North Carolina or for ACC to file in North Carolina, try and get that, what they think probably is a better venue, more friendly venue to them. And we've kind of laid out some reasons why that would be more friendly to them than in the state of Florida. So they're asking for a stay for it to be considered in North Carolina first. Totally understand that. If they can get that done, it'll be a big win for them. A judge will decide on priority and venue and jurisdiction and all those things. So if they can get that, big win for them, it'd be great. Now, for them to ask for that stay in Florida and have it go to North Carolina, and only the items that were not covered in North Carolina to come back to the state of Florida after they're done, I think is pie in the sky. Yeah. I cannot imagine a scenario where a judge in the state of Florida does not at least make an attempt to weigh in on these allegations and this case for a state university, a public entity. To me, that's just they're asking for something that there's absolutely no way. I cannot see that happening. Yep. Where the judge in Florida is not going to at least want to weigh in on the merits of the different allegations from both sides. So I don't see that happening whatsoever. Now, the third part, and to me this is the most important part. Okay. You and I have said from the beginning we thought that this was going to go to a settlement. Yeah. Okay. So how do you get to a settlement? Well, it's move, counter move. One side tries to put the other side in danger, put them at risk. We've seen that back and forth. We saw that in the PAC, and we finally got to a point where everyone's like, okay, well, let's just make a settlement. So for here, to me, this is a counteroffer. So Florida State and their filings, they went with the liquidated damages. Okay, right. This is what we should pay to get out here, and these should be treated as liquidated damages. To me, and I know a lot of people in the media have made a big deal out of this, like, oh, this is huge. The ACC is admitting that Florida State can get out by just paying a penalty. Well, they're asking for instead of liquidating damages, they're saying, well, they can pay this alternative. They can do the alternative performance, which is to pay this larger amount. So to me, Florida State made an offer, and this whole thing, all of this gobbledygook, that a lot of these questions will probably never get answered, like you mentioned. This, to me, the whole thing is all about their counteroffer, and this is basically, we have an offer and counteroffer as we move towards a settlement.
Yeah, and I have not understood those headlines about the ACC is now saying they can get out. That withdrawal penalty has been in the Constitution this whole time.
Yeah.
Now the question is more around, I think, the grant of rights and what liquidated damage, alternative performance, whatever, again, that's a judge that has to determine that. But that's not new news to me. Like, there's always been a way for them to get out. What FSU's trying to determine is the grant of rights even enforceable right now? Is there any penalty associated with that? That's the big question mark, because that goes from the 130 withdrawal penalty to the 500 and whatever number, 42 or whatever the number was, 542 massive difference. So they're trying to get an understanding of the grant of rights. And I've not understood these headlines saying that, oh, the ACC's saying they could get out. They've never said they couldn't get out.
I'm with you on that, but I think it's all about the appearance. So the ACC themselves said when they came up with this grant of rights, it was about locking the doors so nobody could get out.
Correct.
So I think the appearance of the ACC, of what their efforts were, was to basically keep everybody, lock the doors and bar the doors, and so nobody could get out. And their way of doing that was creating such a large penalty.
Right.
It was basically suicide.
Right.
To get out. Whereas now we've kind of moved, at least the perception of how the ACC is acting is they've moved from, hey, trying to keep everyone in, to, okay, if you really want to go, this is what you're going to have to pay. And so that's the next step of a negotiation.
Yeah.
So I don't think anything has changed. I'm with you on that. I think it's just more about the perception by the media, by the public, of what the ACC is trying to do.
Well, and I think I would couch it more around the unenforceability of the alternative performance. Like, the alternative performance, again, it has always been there, and the headlines are like, oh, this is new.
Yeah.
No, it's not new.
Nope.
But I think the enforceability of the alternative, if that's the route the ACC is going, which I shouldn't say if, because that is the route the ACC is going, are those alternative performance measures enforceable? Right. And I don't mean valid from a contractual standpoint.
Are they enforceable?
I mean, are they enforceable?
And those, and you're right, and that's going to be a major question to be answered. And honestly, I could see a judge in North Carolina having one opinion and a judge in Florida having another opinion. So it'll be interesting to see how that goes.
Well, and it gets back, the other comment I'm going to make is it gets back to that, that you brought up, that whole part about, well, if NC rules in favor of, the four of them and there's only a fifth, then only the fifth goes to the Florida state courts. These are two different cases. Yeah. These aren't the same case. Like, that part to me just made absolutely no sense. I question why they would even say that. But again, it's one of those things, I think. We talked about this on other. You throw all the darts you can. Every dart that you can possibly get a hand on, you throw it. Yeah. And you just are looking for anything to stick at this point. That one just seems odd to me. But anyway.
They're trying to splatter paint the wall.
There you go. So let's get into the defenses that doom several claims. First, waiver. Second, quasi-estoppel. And third, a statute of limitations. And the statute of limitations, depending on venue, could be pretty big here, I think. So we'll walk through these quickly. Number one, waiver. Some of the FSU breaches date back many years to the mid-early 2010s because FSU continued to receive the benefits of the contracts over this time. They have waived their claims due to continuing to receive the benefits of the Constitution and the grant of rights. Quasi-estoppel. This theory states that a party who accepts a transaction and accepts the benefits under it may be estopped to take a later position inconsistent with the prior acceptance of the same transaction. The ACC claims that FSU should now be estopped from challenging the validity of contracts under counts 2, 5, 6, and 7 of their lawsuit. The last one, statute of limitations, one that potentially could hold some water here. Florida law states that a statute of limitations for contracts based actions would be determined by the state whose law governs the contract. Also, this has to do with a significant relationship test. In their minds, both of these favor North Carolina law, and that they should be using the North Carolina law and the statute of limitations in North Carolina. The statute of limitations in that state are 3 years for contracts. Lastly, they talk about a motion to stay. When substantially similar cases arise, the first party to the action is where the case should be heard. We've talked about this in other episodes. This is called the principle of priority. If you recall, FSU brought up there are exceptions to a principle of priority. Of course, according to the ACC, none of the things that FSU states show exceptional circumstance that would justify denying the principle of authority. That would then lead you to hear this first. Which case comes first? Principle of authority would say the North Carolina case comes first because they got that in one day before the FSU lawsuit was filed in Florida. So, anything on that, Steve? I want to do some high-level takeaways at the end, but I'll throw it back to you on any of these defenses where they have that might doom some of the claims of FSU.
So, real quick thought on that. They're asking a Florida judge to issue a stay. One of the doom positions is the statute of limitations.
Yes.
So let's just kind of break that down. So they're saying, hey, judge in Florida, we want you to issue a stay and let this be heard in North Carolina. However, there's a statute of limitations in North Carolina, so some parts of this case can't be heard in North Carolina. And also, we're asking you to not hear it in Florida at all, right. Even though you don't have a statute of limitations. We're asking you to not hear the merits of a case that one of the parties is the Florida State University, which is a public entity, and not apply Florida laws because we want it to go to North Carolina and apply the laws there where there's a statute of limitations, sure. So we can't hear part of the case.
Right.
I think that's just a ridiculous ask. I mean, sure, you can ask for anything, but I really have a hard time seeing a judge in the state of Florida accepting that argument and saying, you know what, we're going to abdicate the authority of the state of Florida and the laws of the state of Florida to North Carolina just because you filed yours one day sooner and not hear part of the case where we don't have a statute of limitations because the state of North Carolina does have a statute of limitations. I think it's kind of ridiculous. I don't have a lot of other comments on there. Those things will be decided, but that's just the one part that kind of jumps out of me.
Yeah, for sure. Definitely seems awkward. But again, and this is, I'll get to my final thoughts, and it gets back to what do we need to figure out kind of early on here. And I think once we figure some of these things out, we likely won't get answers to everything else, which is really disappointing because I want answers to all of this kind of stuff from a judge anyway, or at least his opinion. I shouldn't say it's an answer. It's a judge's opinion of the answer, right? But so I think venue is going to be huge. They are both trying to put their case forth as to which venue should this go to first. That is going to be really the first thing that we're probably going to find out in this case. And could that be enough to move somebody to a settlement? Does that increase risk enough to move somebody to closer to a settlement in this? That's a big one really early on before we really learn much of anything else. Is it priority or is it exceptions? Is it priority? Is it exceptions? We'll find out.
I agree with you, and I will say this might seem obvious, but I want to explain why. If if the ACC gets the priority agreement held up where they're able to get this in state of North Carolina first, that is a huge win for them. Massive win for them. They have a chip in a chair. They're in the game. They have a shot at this. If they don't win that priority argument and the state of Florida says, no, we have priority, or they say we're going to hear it here no matter what because there's different contradictory laws, whatever, that is a massive win for Florida State, and that might be a game over kind of thing. We better come to a settlement real quick. So I agree with you 100%, and that's really what I believe the case is going to come down to. A lot of the different legal arguments, like you mentioned, we may never hear.
Right. Well, and let's get into that. So is the contract valid? It kind of gets back, at least part of that is the whole signature piece on that. Again, we did an episode on that. I know we believe that it at least was signed correctly, and I think it is a true and valid contract. Has there been consideration made to the contract? Is it binding? Again, questions that I think the answers are yes to those. But then let's get into some questions about the contract. So let's just assume, okay, we figure out venue. We're going to move forward. It's going to be a contract. None of the issues that they bring up about this contract doesn't even exist right now. A big one is this liquidated damages or alternative performance, which I would love to get a judge's opinion and or answer to on that. We've done several other episodes specific to that exact topic, this whole liquidated damages topic. I would love to hear that. I just don't think we're going to get there. I think something's going to happen before we even get to that, although I'd love for it to happen.
I agree, and I could see a judge. We saw how Judge Levy acted out in the state of Washington. I could see if we get to that argument, I could see a judge telling them like, "Hey," or asking, "Are you anywhere close to a settlement? Because I want to give you time. If you can work this out, if it's going to come down to liquidated damages versus this alternative performance, there's room there for you. Can you come to a settlement before I have to rule? Because one of you is going to be really, really upset if I do rule."
Right. That great point, and he'd asked that exact question. And then some things had to happen after that. He's like, okay, I guess I'm going to have to. And then again, as I said, things moved fairly quickly after he did have a ruling on that. So anyway, hey, I think we got through this. Again, we will probably dive into a couple of these pieces a little bit further as we digest this a little bit more. But with that, hey, we wanted to get this to you guys. We appreciate you guys for watching. We love all the subscribers. Please remember to give this episode a like, give us a subscribe, and with that, we'll see you guys next time on the Big Mountain.